I landed at 0400 on a Wednesday morning in March. 7 months overseas, a deployment that had extended twice. Once for operational reasons I was not at liberty to discuss, and once because the situation on the ground required it, and I was the person the mission needed to stay. 7 months of doing the work I had been trained to do, in conditions I will not describe in detail, with the specific, focused discipline of someone who has learned to keep the personal and the professional in separate rooms in her mind, because letting them bleed into each other is a luxury that the work does not allow. I had 14 missed calls on my phone when I turned it on at the Tarmac. 11 were from numbers I recognized. 3 were from a number I did not recognize that had a local area code. The voicemail from the unknown number was from an attorney's office. Not my attorney's office. An attorney's office I had never heard of, in the city where my mother-in-law, Patricia, lived, which was 40 minutes from the house where my children were. The voicemail said, "This message is for Captain Claire Hartley. This office represents Patricia Hartley in a petition for grandparents' rights filed in family court on February the 14th. Documents have been served at your residence. We ask that you contact this office at your earliest convenience to discuss the matter." I stood on the tarmac at 0400 in the March dark with my bag at my feet, and I listened to that voicemail twice. February the 14th. I had been deployed since August. She had filed in February, 6 months into my deployment, while I was overseas, unreachable except through official channels, serving the country that gave her the rights she was now using against me. She had walked into a family court with an attorney and filed a petition for legal rights to my children. My husband Daniel had been served the documents at our house. He had signed the acknowledgment of service. He had not told me. I had 14 missed calls, and none of them were from him. I called my JAG officer before I called anyone else.
I need to tell you about Patricia, because 7 months of deployment does not happen in a vacuum, and the relationship that produced this moment did not begin in February. Patricia had never approved of me. I want to be precise about this. It was not hostility, not openly, not in the way that could be pointed to directly and named. It was the specific, consistent disapproval of a woman who had a picture of who her son should be with, and who I did not match that picture in ways she had never fully articulated, but had never stopped communicating. She had wanted Daniel to marry someone local, someone from the community he had grown up in, with the values and the priorities and the presence that community implied. I was not local. I was a United States Army officer whose career required mobility and commitment and a relationship with absence that Patricia found, I think, genuinely incomprehensible. She did not understand why someone would choose a life that took them away from their family. She did not understand, or would not understand, that the service was not a choice made against the family, but a commitment made alongside it. She said things over the years that I filed and did not respond to, that the children needed stability, that a mother who was always leaving was not the same as a mother who was always there, that she worried about what my career was doing to Daniel and to the children, and to the family that she had a significant interest in, given that it contained her grandchildren. I had heard all of this, and I had managed it the way I managed things, with patience, with the understanding that her concern for the children was genuine even when its expression was not fair, with the discipline of someone who has been trained to work with difficult people in high-pressure environments, and who applies that training to her personal life because it is the only training she has. I had not anticipated the courthouse. I had not anticipated that Patricia's concern for the children would translate, while I was 7 months overseas, into a legal filing, and I had not anticipated that Daniel would receive the documents and sign the acknowledgment and not contact me through any of the channels available to him for official communication with deployed personnel. My JAG officer's name was Captain Marcus Webb. I had worked with him before, not on anything personal, but in the professional capacity that JAG officers and line officers sometimes intersect in, and I trusted him with the specific, earned trust of someone who has seen a person perform under pressure and found them reliable. I called him at 0430 on the Tarmac because the debriefing was not until 0800, and I had 3.5 hours, and I was not going to spend them not knowing what I was dealing with. He answered on the third ring. I told him what the voicemail had said. I told him the date of the filing. I told him that my husband had been served and signed and had not contacted me through any of the channels available to him for official communication with deployed personnel. Marcus was quiet for a moment. Then he said, "Send me the voicemail, and get me everything you have on the official communication channels, the dates you were reachable, the protocols your husband was given before deployment. I want to see what he had access to and when." I said, "I can have that to you by 0800. He said, "Do that. And Claire, don't call Daniel yet." I said, "Why?" He said, "Because what you say to him in the next 24 hours is going to matter, and I want you to know exactly what you're dealing with before you say it. Can you do that?" I said, "Yes." He said, "Good. I'll see you at 8. I hung up, I picked up my bag, I walked off the tarmac into the processing facility, and I began the paperwork of returning, which is its own long process, and I held everything I just learned in the part of my mind where I held things that needed to be held while other things were being handled. I was very good at holding things. The debriefing was 3 hours. Then Marcus. Marcus had spent the time between 0430 and 800 doing what JAG officers do when they are given a situation and told to understand it, building a complete picture quickly from available information. When I sat across from him at 8:15, he had a file that was already substantial. He said, "Grandparents' rights petitions are filed in family court. They vary by state, but in your state, the petitioner, your mother-in-law, has to demonstrate that visitation with the grandchildren is in the best interest of the child and that there has been some interference with that relationship." I said, "There has been no interference." He said, "I know. That's going to matter." He said, "The filing date is February 14th. You deployed in August. Between August and February, she had regular access to the children, weekends, holidays, the standard arrangement you had in place." I said, "Yes." He said, "So the petition is being filed during a period when access was uninterrupted during a deployment against a service member who was overseas at the time of filing." I said, "Yes." He looked at me. He said, "The Servicemembers Civil Relief Act provides specific protections for active duty service members in civil legal proceedings. A court is required to stay proceedings when a service member's ability to appear or respond is materially affected by their military service." I said, "She filed anyway." He said, "Her attorney either didn't know about the SCRA protections or decided to file and let the court sort it out. Either way, the filing during active deployment is going to be significant." He said, "The other significant thing is your husband." I said, "I know." He said, "He was served. He signed. He had access to official communication channels. I've pulled the documentation. He had the ability to notify you of the filing through proper channels, and he did not use them." I said, "I know." Marcus looked at me carefully. He said, "How are you doing?" I said, "I'm doing what needs to be done. What's next?" I called Daniel at 1000. Not from emotion. I was past the stage where the call was going to be driven by emotion. I called because I had the information I needed, because Marcus had walked me through the landscape, and because Daniel deserved, before the formal legal process began to move, to hear from me directly. He answered on the first ring. He said my name in the voice of a man who had been waiting for this call and who had not been sleeping well. I said, "Tell me about February 14th. He said, "Claire." I said, "Tell me about February 14th. He told me. The version he told was the version I had partially expected, the version in which his mother had come to him with the petition already prepared, with the attorney already retained, and had presented it to him as something she needed his cooperation on, and had pressed him until she had it. the version in which he had felt he had no choice, which I did not accept as a factual statement, but which I understood as a description of how he had experienced it. I listened to the whole version. Then I said, "You had communication channels. You had the ability to notify me through official protocols. You chose not to use them." He said, "I didn't want to. I couldn't do that to you while you were—" I said, "You didn't want to tell me my mother-in-law was filing for rights to our children because you didn't want to disturb me during deployment. Is that what you're saying?" Silence. I said, "Daniel, my JAG officer is filing a motion today to stay the proceedings under the Servicemembers Civil Relief Act. The court will receive documentation that this petition was filed against an active duty service member during deployment, that the service member was not notified through available channels, and that the petition was filed during a period when the subject grandparent had uninterrupted access to the children and therefore cannot demonstrate the interference the petition requires." I said, "Your mother is going to lose, and the manner in which it was filed and the manner in which you responded to it is going to be part of the record." He said, "Claire, I'm sorry." I said, "I know. I'll call you when I'm home."
I want to tell you about the court hearing because it is the part of this story that I think matters most, and it is not the part you might expect. The hearing was 6 weeks after I landed. The stay had been granted immediately, the SCRA protections are not ambiguous, and the court had applied them without significant delay. When the stay lifted, Patricia's attorney appeared before the judge with the petition. Marcus had prepared everything: the deployment record, the communication protocols, the documentation that Daniel had been notified and had signed and had not used available channels to inform me. The record of Patricia's consistent access to the children during the 7 months of deployment, weekend visits, video calls, holiday arrangements that I had put in place before I left specifically to ensure the children's relationships with both sides of the family were maintained while I was gone. I was in the courtroom, in uniform. Patricia was there with her attorney. She did not look at me when I came in. She looked at the table in front of her in the way of someone who has had 6 weeks to think about what they did, and who has arrived at the hearing with a different understanding of the situation than the one they had in February. Her attorney made the argument. It was not a strong argument. I had understood from Marcus that it was not going to be a strong argument, that the filing had been premature and strategically poor, and that the best outcome Patricia could realistically hope for was to withdraw the petition without prejudice and try to manage the relationship outside of court. The judge was a woman in her 60s, with the specific, efficient manner of someone who has seen many things and who forms opinions quickly and accurately. She looked at the record. She looked at the deployment dates. She looked at the documentation of Patricia's access during the deployment. She looked at me. Then she said, "Counsel, your client filed this petition during the active military deployment of the respondent, during a period when she had uninterrupted access to the children in question, without utilizing available channels to notify the respondent, against a service member protected under federal law." She said, "I'm going to ask you to explain to me what the basis for this petition is." Patricia's attorney said something. It was not a compelling something. The judge dismissed the petition. Not stayed, dismissed, with a notation in the record that I will not quote in full, but that used language I had not heard from a judge before and that my attorney described afterward with the understated precision of someone who does not say things for effect as unusually direct. I sat in the courtroom in uniform, and I looked at the table where Marcus's file was, and I thought about 0400 on the Tarmac, and the 14 missed calls, and the voicemail from the attorney's office, and the specific, particular anger of landing after 7 months of service to find a court filing waiting. And I thought, she chose the wrong soldier. Patricia called me 2 weeks after the hearing. I answered. I had decided before she called that I would answer because I am someone who believes that things said directly are more useful than things left unsaid, and because there were things I needed to say to Patricia that a courtroom is not the right room for. She said, "I want to explain." I said, "Okay."
She explained. The version she gave was not entirely different from what I had already understood. The fear, the 7 months of the children's lives that had felt uncertain to her, the specific anxiety of a grandmother who loves her grandchildren and who had convinced herself that doing something was better than doing nothing. I listened to all of it. Then I said, Patricia, I had put arrangements in place before I left. Video calls, weekend visits, holiday schedules. I had done everything I could from overseas to make sure the children's relationship with you was maintained while I was gone. While I was doing that, you were in a courthouse. She said, I know. I said, I want you to understand something. I have spent 12 years serving this country. I have deployed 3 times. Every time I leave my children with the people I trust to protect them while I'm gone, not to use their access to those children as leverage in a legal filing. She said, I understand. I said, I hope you do. I said, the arrangements I put in place before deployment still stand. You are welcome in my children's lives. But what you did in February is not something I'm going to pretend did not happen, and it is not something that is going to happen again. She said, it won't. I said, good. Then I ended the call.
My children do not know about the court filing. They are 7 and 4, and the details of what their grandmother did while their mother was deployed are not details they need to carry. What they know is that Mommy came home, that Mommy is always coming home, even when coming home takes longer than anyone wants, that the Army takes Mommy sometimes, and Mommy always comes back. Marcus, who is 7 and who has the particular watchful intelligence of a child who pays attention, asked me once if I was ever scared when I was deployed. I said, sometimes. He said, what do you do when you're scared? I said, I do the next thing. Whatever needs to be done next, I do it, and then the thing after that. He thought about that. He said, is that what you did when you landed and found out about Grandma? I looked at him. I said, how do you know about that? He said, I heard Dad on the phone. Children hear things. I have known this for 7 years and I still underestimate it. I said, yes, that's what I did. I did the next thing. He said, what was the next thing? I said, I called someone who could help. He said, Captain Webb? I said, yes. He said, I want to be a JAG officer. I said, you'd be good at it. I am telling you this story because I think there are women who need to hear it. Women who are serving, who have served, who are in the particular position of loving their families and also having made a commitment that takes them away from their families, and who worry in the Army deployment dark about what is happening at home. I want you to know something. The law protects you. The Servicemembers Civil Relief Act exists. Your JAG officer exists. The documentation of your service exists, and it matters in every proceeding that involves it. You do not have to choose between serving and fighting for your children. You can do both. You can land at 0400 with 14 missed calls and a voicemail from an attorney's office, and you can make the right call first, and you can be in a courtroom 6 weeks later in uniform, and you can watch a judge read a record and use language she does not normally use. You can do the next thing, and the thing after that, and you can come home. You always come home. She doesn't stay silent. She doesn't stay broken. She rises. Sometimes rising is the phone call you make at 0430 on a tarmac before you call anyone else. Sometimes rising is knowing who to call first. Subscribe. New story every week, and every single one of them ends the same way. She rises. Leave a comment. Have you ever had to fight for your children while you were fighting for something else at the same time? I read every single one.